Hello, my name is Michael Tesoro, and I've prepared this presentation on the Banking Cartel case, which was recently saw the charges withdrawn on the 11th of February. So I thought I'd just summarise the case from the beginning to the end, but admittedly a very bad pun there. But the idea behind the pun is that there doesn't seem to be any winners from this particular case. Everybody has come out badly. I think the ACCC and the DPP have come out very badly, but it's been a very bad outcome for all the individual defendants as well. So I think From Go to Woe really captures the way this case has progressed through the courts. Now, a bit of background about myself. I'm a competition and consumer lawyer. I've been running my own business for about 13 years, Tesoro Legal Consulting, and I help companies with competition and consumer matters, investigations and litigation. I've also done a bit of work in relation to criminal cartels. I've helped a few companies who were being investigated by the ACCC in relation to criminal cartel, and also provide a bit of advice to some banks, large banks, about the implications of the ANZ case. So they were obviously concerned about what that case meant for them. Also, prior to that, I worked at the ACCC, a variety of roles, but one of the roles was Director Enforcement, and I left the ACCC before the criminal cartel laws came in, so I don't have any regulator experience in relation to that. But I did run a few criminal investigations and litigation when I was at the ACCC, so I have an understanding of preparing a brief of evidence, of working with the DPP, and how the evidentiary requirements, how high they are in order to run a criminal case. So some of those insights may be of assistance in understanding what happened in this case. Now, outlining the presentation, I'll start with a quick outline of what the case was all about, talk a little bit about the initial filing, also the committal hearing. The big issue really was the challenges to the indictments and the two judgments by Justice Wigney about the indictments, then the decision to withdraw the charges, really without saying very much about why the charges were withdrawn, then discuss the possibility of the defendants getting back their costs, brief discussion of that, then finally some lessons learnt. So the background of the case was announced on the 5th of June 2018, but there had been some previous announcements in relation to the case. The ANZ made a market announcement earlier on, and that forced the ACCC to issue a couple of press releases foreshadowing the charges being laid, and then when the charges were laid, this press release was put out. And as you can see, I've just prepared a chronology, and I'll run through that fairly quickly, but you can see there the companies and individuals who were taken, were charged in relation to this cartel. There was Citigroup, Deutsche Bank and ANZ. 3 individuals from Citigroup, 2 from Deutsche Bank, or actually formerly from Deutsche Bank, and 1 from ANZ. And then the matter went into the local court for a committal hearing, which went for a very long time. And finally, on the 8th of December, the magistrate made a decision to commit all the parties for trial in the federal court. On the 1st of February, the first indictment was filed by the DPP, and that was immediately challenged by all the defendants. And on the 7th of July, Justice Wigney handed down his first decision in relation to the indictment. He decided that the prosecution should be given the opportunity of filing a second indictment, which was filed on the 16th of August. And I think interestingly, some charges were withdrawn after that second indictment was filed. So the charges against Mr. Roberts from Citigroup were withdrawn, and also the charges against both ANZ and Muscati were withdrawn. So on the 18th of August and the 29th of October, quite a number of charges were dropped against individuals and one of the corporate respondents. Then on the 3rd of November, Justice Wigney handed down his second judgment in relation to the second indictment, and this was really scathing judgment about the performance of the DPP in trying to prepare an indictment. In actual fact, I think he concluded this indictment, the second indictment, was probably worse than the first indictment. So I'll go through that in a bit of detail because that's quite important law. Then on the 24th of November, that was the date for the prosecution to file the third indictment. So after the Wigney decision, he gave until the 24th of November to file a final third indictment. And it's final in the sense that if they were unable to file an indictment by that date, there was like a guillotine order. There was no further chances. And then on the 11th of February, the DPP withdrew all the charges under Section 9, subsection 4 of the Director of Public Prosecutions Act. Now, the background to the case arose out of a share placement for ANZ back in 2015, where there was 80 million shares being offered to the market. The underwriters were Citibank, Deutsche Bank and JP Morgan, and there was a significant shortfall in the take-up of the shares. And so 25 million shares valued at 800 million were unsubscribed. So they had to be picked up by the underwriters. And the alleged cartel arose from a series of conversations and meetings that occurred between the underwriters and ANZ, where there was an agreement to sell down the shortfall of shares, which was in the possession of the three underwriters, progressively, rather than to sell them down all at once. So obviously that makes sense, because if you throw 25 million shares on the market at one time, there will be a real market destabilization, particularly if you're talking one of the big banks, his share price is tanking and dropping very rapidly. That's going to send probably the whole market into a bit of a frenzy. A lot of people are going to panic. So selling them out progressively clearly advantages the goal of having a stable market. But also ANZ, you know, if the price, if the shares were all sold at once, their share price would go down very rapidly, which is not in their best interests. And finally, the underwriters, if all those shares went on the market, the price would depress and they wouldn't get a very good return from their shares. So there's clearly a public benefit argument here, but there's also a lot of private benefits that the ACCC was focused on. So the matter goes from that initial stage to the committal, and this is the interesting thing, it goes to the local court, which doesn't deal with competition and consumer law matters very well at all, really, competition matters at all, and obviously doesn't deal with complex cartels. And so this magistrate gets this case, and first day of the committal hearing, there's like silks from wall to wall. Probably more lawyers in the room than has ever been in a local court committal hearing ever before, and it's a very intense atmosphere with the defendants' lawyers really raising every argument they can, demanding that ACCC investigators and JP Morgan witnesses be brought into the court for cross-examination. Lots of allegations are made about the ACCC. Unfortunately, it was such a major committal that it languished, and that's the word that Justice Wigney used, at the committal stage for 30 months. So it was there for a very long time. But the thing about a committal hearing, the test is a very low standard. All the magistrate has to be satisfied is that there was sufficient evidence to justify the defendant being committed for trial. So it was always likely that that was going to be achieved by the DPP. But I think the bigger issue was that the defendants wanted to flush out as much evidence as they could from the ACCC. They were given the right to cross-examine a lot of ACCC people and JP Morgan immunity witnesses. They also threw a lot of allegations at the ACCC which weren't established, and I'll just come to those allegations. So these are some of the allegations that were put to the ACCC in the course of the committal. Firstly, that some ACCC investigators have been tidying up witness quotes from memory, so they sort of maybe their own artistic license in terms of what was in the statement, sent draft witness statements to their own personal email account so they could work at it at home, which breaches a lot of the strict security protocols which the ACCC implements in relation to these type of matters. Allegations that witness statements were pre-populated with incriminating claims before the witness was interviewed. This arose from some recordings of meetings which were in the ACCC's possession, and the allegation was that the ACCC officers listened to the recording, prepared a statement, and then sent it to the witness to sign off on, which is really not the right way of doing things. If established, like none of these have actually been established, they were all allegations raised at the committal hearing. Also, that there were allegations of deletions of exculpatory material from some of the JP Morgan witness statements, which is a very serious allegation, obviously. And then there was this sort of strange allegation that ACCC investigators hadn't kept written notes of their 50 plus days of witness interviews, which isn't necessarily the wrong thing to do. But then there was an admission by one of the ACCC investigators in the witness box that he did have some private notebooks, but he disposed of them every 2 or 3 months. So clearly having private notebooks and taking notes and disposing them is not proper practice at all. You've got to keep things. There's a strong duty of disclosure in criminal matters. But the idea of not taking notes is not wrong at all. In actual fact, the ACCC should be videoing or recording these interviews, not taking lots of notes, because realistically, the more people taking notes, the more likelihood there'll be inconsistent versions of the witness's evidence, which could end up in the defendant's hands in terms of JP Morgan witnesses, which will give the defence a really good opportunity to attack their credibility. So I think when the ACCC is investigating a criminal matter, they really should be recording it some way. I remember when I did a number of criminal investigations at the ACCC, we'd bring out the triple deck tape recorder and record the entire interview, and nobody would take any notes, because you don't want a version of the interview in handwritten notes that contradicts what's on the recording. So that was strange to me, that the ACCC were taking lots of notes at all by hand in a criminal interview. Really should be recording those types of interviews. And there were some other allegations that they were interviewing JP Morgan witnesses with lawyers from their law firm in the room, which again seems not best practice to me. When you're interviewing a witness in a criminal matter, the only people in the room are the investigators. You don't have any third-party lawyers in that room. Now, after the committal occurred, the defence attacked the indictment that had been filed and made a number of allegations about the absence of essential factual ingredients. And so Justice Wigney sustained those complaints. He believed that the indictment in a number of respects didn't sufficiently identify those essential factual ingredients, and accordingly he directed the DPP to file the new indictment. The issue he had to wrestle with was whether the deficiencies were so bad that he could quash the indictment, and he balanced up the factors there. On the one hand, the fairness to the accused, but on the other hand, the public interest in having serious criminal charges heard by a jury. And once he balanced up those two factors, he decided that the appropriate course was to give the DPP another chance. However, one thing that's really interesting about this particular judgment is the drafting advice which Justice Wigney effectively gave the DPP. He not only looked at the deficiencies in the way the indictment was drafted, but then he included his proposed amended version, which would satisfy the requirements of the rules and would obviously avoid the deficiency. So he actually helped them quite a bit in the way to formulate the indictment in a way that would pass muster. And I guess one interesting thing that people have to consider at this stage is the strategic issues around going after the indictment or not going after the indictment. Clearly, if you go after the indictment, you may be successful in quashing it, and then the whole case is thrown out, and that's a good outcome for the defence. But it is a rare occurrence. It's rare to have an indictment thrown out, particularly something that's been through a very rigorous committal process. So you've got to be aware that trying to have the indictment quashed is a low probability, but it could be of great advantage to the prosecution, because you're identifying problems with the indictment, you're identifying areas which are confusing or don't make sense, and you're giving the prosecution an opportunity to fix all those things up. And the more they fix those things up, the clearer the indictment becomes. And the more likely, if the case gets to a jury, the jury will understand the indictment and find your client guilty. So there can be a downside here. It's much better for an indictment that's vague and unclear and doesn't make sense to go to a jury. Your chance of getting acquitted are much higher. So I think you have to weigh up the advantages of going after the indictment and spending a lot of money in challenging the indictment versus letting a poorly drafted indictment go through to the jury. So between the first indictment and the second indictment, a number of charges were dropped. So on the 18th of August, the DPP withdrew charges against Mr. Roberts from Citigroup, and then 29th of October, they dropped the charges against ANZ and Moscati. So the second indictment was also challenged very strongly by the defendants. And the main changes that occurred in that second indictment was a significant reduction in the number of charges. There'd been 3 events which the DPP had alleged were cartel provisions: the Friday understanding, the Monday understanding, and the 5 to 7% understanding. And in the second indictment, the Friday and the Monday understandings were removed, and it is entirely based on the 5 to 7 understanding. And this is why the case against the Citigroup employee could not proceed, because he was only implicated in one of these 2 agreements that was dropped. And then the other changes was to amend the way in which accessorial liability was pleaded in the indictment. So they amended the indictment to rely on section 11.23a of the Criminal Code, which takes a different approach to accessorial liability than the relevant provisions of the Competition and Consumer Act. And it really does rely on characterising conduct of a particular type and alleging that the person was engaged in conduct of that particular type. So the problem was that they needed to make it clear what the conduct was, particularised as cartel conduct in the 5 to 7% understanding. Now, what Justice Wigney held was that the accused arguments about the problems with the indictment were upheld, and effectively the indictment was deficient. Again, he balanced up the public interest in the charges going to the jury versus the unfairness to the accused, and decided, on balance, he wouldn't quash the indictment. And this was a close call. He could see that he was really considering quashing the indictments, but he thought it just got over the line. But he did order that the DPP would just have one final chance to file an indictment that complied with the rules and the common law requirements. So effectively a guillotine order was made by the judge. Now, in the course of his judgment, Wigney was very critical of the DPP, and he made this very memorable quote that he described the proceedings as a complete schmozzle, critical of the committal proceedings and how very little had actually come out of those of any relevance, that you've got 3 years after the individuals are charged and the corporation's charged, and the indictment hasn't been finalised yet, and there's only 6 months before the trial's supposed to commence. So that's a very unsatisfactory state of affairs. He also was very critical of the fact that the prosecutor hadn't been taking any real notice of the criticisms that they'd been alerted to by the defence. So the defence is writing to the prosecutor saying there's problems here, there's problems there, and they hadn't been placing a lot of weight on those criticisms. But more significantly, it seemed that the prosecutor hadn't taken a lot of note of the assistance which the court had effectively given the DPP to fix up the indictment in the first judgment. So as you said, as it says there, in the judgment of this court, which provided detailed guidance as to the elements of offence in question and what needs to be included. So Wigney's saying, not only have you ignored the defence correspondence and proposals for changes, but you've actually ignored the court. The court effectively told you how you could fix this up to make it valid. But Wigney was also very critical of the legislation, and he made this very interesting comment saying that people who drafted this cartel provision couldn't have known the first thing about criminal trials, because the way they've drafted this is akin to a cryptic crossword. And he just talks about the extensive definitions, and he says the defence provisions are prolix, convoluted, and labyrinthine. So you've got just the cartel provisions are almost impossible to use. And then he says when you couple that with the accessorial liability provisions, particularly those in Chapter 2 of the Criminal Code, then the complexity is just, multiplied by a great number. And so he's giving, I guess, some sympathy to the DPP that it really is easy, given how complex the legislation is, that you can lose sight of what you're actually trying to do. And that's what the DPP failed to do in that second indictment. So then you've got the situation where the DPP decides to withdraw all the charges. So on the 11th of February, the DPP decided to withdraw the charges. That's Nolle, prosequi, I think that's the right way to pronounce it. And effectively, it's a no bill. You're basically saying that the charges have been withdrawn. And it's under Section 9, subsection 4 of the Director of Public Prosecutions Act, which is just a very vague provision which says that the DPP has decided to withdraw the charges. It doesn't provide any reasons, and there have been no reasons expressed about why they withdrew the charges. But usually when there's a no bill application, there's two main grounds where it might be no billed. And the first one is that there's insufficient evidence to establish the case. And secondly, it's not in the public interest to proceed with the charges. And so looking at those two reasons, you'd have to think it's probably the first reason. There was just insufficient evidence to proceed. Now, one issue that arises is that will the defendants be able to recover their costs? And usually in criminal cases, you can't recover your costs. But having said that, there are a few exceptions that do apply under the case law. And the first one is really focused more on the investigator, so more on the ACCC. So in the investigation into the alleged offence, there was unreasonable and improper behaviour. So clearly there's been a lot of allegations raised in the committal, which may lend a basis to alleging that there was unreasonable and improper conduct by the ACCC. Then there was an argument that the proceedings were initiated without reasonable cause or in bad faith, and that's really focused on the DPP. I think that'll be harder to establish with the DPP, particularly bad faith or proper manner. We don't really know how they made the decision to commence proceedings, but it's contrary to my experience. I must admit, when I ran some criminal cases with the DPP, they were very rigorous, very particular about having evidence to establish the charges. A couple of the briefs I referred to DPP got rejected because they didn't believe the evidence was strong enough. So I'm very surprised that this got past muster, really, with the DPP, given my experience with them of how conservative they were on evidentiary issues. There's also an allegation that prosecution unreasonably failed to investigate relevant matters or was reasonably aware that there were issues which suggested the defendant might not be guilty. Again, it's a hard one to establish, but I guess there was a suggestion by some of the JP Morgan witnesses that there was never a meeting of minds, it was never agreement, that it was actually independent decision makers. Independent decisions were being made. So the question there is whether there might be any exculpatory information that wasn't disclosed by some party. Again, that'd be, I think, unlikely, but more focused, I think, on the ACCC than on the DPP. The final one is other exceptional circumstances, which, as you can imagine, is a very broad category. But I think the one that sticks out here is you've had a case gone through committal. It's been 3 years going through various processes, and after 3 years, the DPP can't actually file a valid indictment. So that seems to me pretty exceptional, and that may be the best basis on which the defendants seek to recover their costs, particularly individuals, because as we know, individuals can't be indemnified by their employers. So all these individuals have been filing this case out of their own pockets for a number of years. It would have cost them so much money. So it seems to me that if anybody's going to get costs back, it should be those individuals. And I think Wigney's going to definitely look at this issue very closely. Now, the lessons to learn from this particular case are many. But the first one is the clear observation that the law is unworkable, like the cartel provisions are unworkable. And I think a good way of seeing it, like it's a bit simplistic, but you look at the Sherman Act, Section 1, it's 96 words long. That's all it is. And there've been many successful prosecutions in the US, putting a lot of people in jail. And in Australia, the Central Cartel Provision, Section 45 AD, is almost 1,750 words. And then if you take into consideration the whole cartel law, it's 4,500 words almost, with defences and all sorts of exceptions. It's simply an unworkable bit of legislation. And I think that was identified by former federal court judge Peter Heery when he identified the law as being prolix and really very difficult to apply. But here he's pointing out that this is a serious issue. Like, not only is the law very hard to apply, but judges are going to struggle to formulate a direction to a jury that they can understand to actually, convict somebody. And then he makes a very good observation that this has to be got right, because not only won't you get convictions, but the individuals who are charged are facing imprisonment or financial ruin. Like, it could be both, but even if they're acquitted, they could be facing financial ruin. So the problems with the legislation have been around for a very, very long time. Now, one other thing that's really important is really the only jurisdiction that puts people in jail regularly is in the US, the Antitrust Division. And so it's important to look at the way they do things and see if the way they do things has been replicated in Australia. And one particular area where it just has not been replicated is the way that cartel cases are investigated. What a lot of people don't realise, that in America, the Antitrust Division relies very heavily on experienced FBI agents to conduct the entire investigation. Not just they do a couple of things like the AFP in Australia, like planning the listing devices. They do everything. They interview potential defendants, interview leniency applicants, obtain information for third parties through subpoenas, chase up investigatory leads, manage a chain of evidence, obtain and analyse the documents, give evidence in court or before the grand jury, execute search warrants, install listening devices, wiretaps. They do everything. And when a case is announced in the US, they have a contact names at the bottom of the press release, and one of them is an Antitrust Division person and one's an FBI agent. And the FBI agent is the person you contact if you've got a lead. So the level of involvement of the FBI in investigating cartels is very different to Australia. The ACCC, is an investigative body, but I don't think it's be the same sort of expertise as the FBI. As I said down the bottom there, the basic training that the FBI agent gets is 20 weeks, intensive training at the FBI Academy, plus a lot of follow-up training. So in Australia, the ACCC officers get quite rudimentary training. I think that came out in some of the evidence in the committal that the training that the ACCC guys are getting is really not on a par with the FBI. So this is a very big difference, and you've got to wonder if the reason they're successful in America, in the US, is because they're using the FBI to do all this investigatory work. The second thing is, in the US, they have a grand jury. And I think we've all seen TV shows where the grand jury is empaneled to consider a particular case. But in terms of antitrust criminal cartel matters, a grand jury is convened in every single investigation. And the grand jury has a wide range of powers. Like, it's not just a bunch of people sitting around listening to a prosecutor and agreeing to issue an indictment. It's actually, they have extensive powers of investigation. As you can see there, it's been described in that case of Blair v. US as a grand inquest, a body with powers of investigation and inquisition. The scope of whose inquiries is not to be limited narrowly by questions of propriety or forecast of the probable result of investigation. So they can issue subpoenas, they can bring witnesses in, they can kick the witnesses' lawyers out of the room, they can require secrecy from people they've interviewed. They have extensive powers, and I think that's a big difference to the way things operate in Australia, where the ACCC relies on a limited number of Section 155 powers. So that's another big difference in the two jurisdictions. So I think just some commentary, like, clearly the law has not worked out in this particular case, and it's been a disaster. And I think you're looking at the case selection, like, you're wondering when the ACCC selected this case, did it really give a good thought to the criminality of the parties involved in the matter? Because I know when I was dealing with the DPP back at the ACCC, they emphasised to me that criminality was a big issue, that you had to be satisfied that the person you wanted to charge had an awareness that what they were doing was wrong, was against the law, that they weren't just ignorant of the law or thought it was all right. They genuinely knew what they were doing was wrong. And so that was the extra factor that we had to satisfy the DPP about before they would file the charges. In this case, it's hard to see that there was criminality. These particular bankers were engaging in conduct that seemed to be well accepted in the market, that the strong inference that the financial regulators were fully aware of what was going on, thought that it was beneficial in the sense of not destabilising markets. And so there seemed to be a real absence of criminality in this case. And that's a real big problem. I think the ACCC needs to be satisfied that people who are charged criminally have an understanding of what they're doing is a criminal offence or wrong. The second thing is the legislation is a mess. It's always been seen as being overly prescriptive, lots of defences, which raises question marks over how can conduct be criminal if there's a defence you can raise to it. It sort of creates a bit of inconsistency. So the legislation needs to be rewritten, and I think it's important for I guess all parts of the legal profession to maybe put that to government, that the law needs to be rewritten to make it workable and fairer, because you can't have individuals being charged with criminal offences and going 3 years before a valid indictment is filed, and actually maybe was never filed, and then the matter's no bill. So I think there's a real importance in looking at the legislation and writing it again. The other thing is there are a few people pleading out. Like there was a recent case involving chemicals where an individual and the corporation pleaded out, and there was another cartel against a number of money broken individuals where a number of people pleaded guilty. And you're just wondering why are these people pleading out? Like, are they pleading out because they're getting a strong view that they're going to get convicted, or are they pleading out because they just can't afford to fight the ACCC? And I think if it's the latter, then that's a big concern. We shouldn't have people pleading guilty to criminal offences because they just can't afford to contest the elements of the offence. So I'm a bit concerned that the two matters that have progressed to a certain extent have been the Country Care case, which the jury acquitted all the defendants in a record amount of time, and in this case has been no billed after 3 years. And then some other smaller companies and companies maybe less willing or able to fight have been pleading out. And I think the main thing is I think the case has sort of highlighted the need to improve investigator training at the ACCC. I still can't understand why investigators are handwriting notes in criminal cases, should be taping the whole thing. There's triple deck recorders from when I worked there that we always used to use for criminal investigations. Chain of evidence is very important. So I think there has to be a lot more focus on that. The one thing we can't do in Australia is change a whole system to set up a grand jury. So that's a luxury that we'll have to do without. So I hope that was helpful. I think that this case has been a real disaster. I think that there was a certain amount of rushing at the beginning to get into court, and I still can't understand how the DPP were so satisfied to commence these proceedings against so many companies and individuals. I think when there's sort of new issues coming along, it is important for the ACCC to do two things. Firstly, to look at the civil option first, to pursue the civil option, and also not to sue lots of individuals. Like if there's a practice in an industry that seems to be well accepted, like underwriters trying to manage risk, then the ACCC can still take a case, but take a civil case against the corporations and alert everybody to the concerns about the conduct. But to go with a criminal investigation in in that context, and to sue so many individuals, 6 individuals, is really, in my view, quite unfair. And I think it was a mistake by the ACCC, and I guess it's good that the outcome has come the way it has, that the whole matter has been no build, but it's been really a lose-lose situation for everybody, for the DPP, for the ACCC, and particularly for the personal defendants. So that's all I've got. If you've got any questions or comments, feel free to give us a call or drop me an email. Bye-bye.